Madam Speaker, it's a pleasure for me to rise today to speak on important legislation, Bill C-14, bail reform and sentencing reform. But before I do that, I want to advise you, Madam Speaker, that I'll be sharing my time with the very effective Member of Parliament for Surrey Spruce Mountain. So, Madam Speaker, here we go again, Bail Reform 2.0. In the 44th Parliament, we had Bill C-48, brought to you by the Liberal government under Justin Trudeau. That bill was in response to several high-profile violent crimes committed by people who were, at the time of that crime, out on bail on charges of other violent crimes. Take, for example, Randall McKenzie, who murdered OPP officer Constable Greg Pershella on December 27, 2022. That murderer was out on bail, at that time awaiting a trial on charges of violent weapons-related crime against his girlfriend. Interpartner violence, we call that. He was in breach of his bail conditions, of course, having a weapon in his possession and having removed his ankle bracelet and having left his home. That's where he was supposed to be. There had been a warrant for his arrest for about 6 months, but the police had failed to apprehend him. Too many people out on bail, not enough police resources. This man was getting away with murder. Too many people out on bail. That was the problem at the heart of this. This man should have been behind bars, pretrial incarceration. Now, there are other high-profile cases at that time. I raised this one because it really woke up the public to weaknesses in our criminal justice system. And when the public gets concerned over a public policy issue, politicians scramble to get ahead on the story. Now, in a rare show of cross-country, cross-party cooperation, all the premiers of the 10 provinces and of the 3 territories wrote a letter to the Attorney General and to the Prime Minister demanding bail reform. And the response to that was A.G. Lametti at that time introducing a very weak bail reform bill, C-48, that made it just slightly more difficult for people like Perschella's murderer to get out on bail while awaiting trial. The accused now had to convince the judge that he could be trusted to be out on the streets, instead of the government lawyer having to convince the judge that the accused should stay behind bars. That's a reverse onus, we call that. It was a slight improvement from a law and order perspective. We supported the bill, we the Conservatives, because it was a step in the right direction. Provincial politicians and law enforcement agencies across the country supported it too, although many expressed disappointment that it simply did not go as far as they had hoped. So why didn't the Liberals go further? When the public sentiment was clearly on the side of going further with bail reform. Now, the underlying challenge for them was a previous bill from the 42nd Parliament, and that is Bill C-75. It was one of the last enactments of the 42nd Parliament before it rose for the summer. And it was that bill that introduced the principle of restraint in bail hearings, the principle that directs the judge to release the accused at the earliest possible time on the least onerous conditions. That is set out in section 493.1 of the Criminal Code, which I'll just quote a little piece of it. Consideration should be given to the release of the accused at the earliest reasonable opportunity and on the least onerous conditions that are appropriate in the circumstances. And that's what happened to Mr. McKenzie. He was out, the murderer of Constable Pershella. He was out on bail under his mother's supervision with an ankle bracelet, not to leave home, weapons prohibition, and all this for a man who had been charged and was awaiting trial on charges of violent crime against his girlfriend with a weapon. So how's that even right? How can that happen in this country? It's easy to point the finger at the judge, as some people did, but the judge was responding to the principle of restraint that was introduced by the Liberal government in C-75. Now, we hear from the Liberals say, well, we had no choice. The court told us that we had to do that in a case called R versus Antic. Now, and indeed, the Supreme Court of Canada, Chief Justice Wagner writing, did say that there should be releases favored at the earliest reasonable opportunity and on the least onerous grounds. It is true. that the court did say that. But we've always argued, Conservatives, that the Supreme Court of Canada never directed Parliament to throw open the gates to unfettered bail. It didn't direct Parliament to introduce new legislation. It didn't direct Parliament to do anything. Antic was a case that simply clarified some confusion around the rights of the accused when it comes to bail, the right to be presumed innocent, the right to a fair trial with the burden of proof on the Crown's lawyer, and the right, of course, to reasonable bail as set out in our Charter of Rights and Freedoms. Antic was not a case where the court had struck down any legislation under Section 52 of the Constitution Act, the so-called Supremacy Clause. That does happen from time to time, as happened a few years ago in a case called R versus Nidlova, which was decided in 2022. The court in that decision said that a certain section of Section 490, subsection of 490 of the Criminal Code, the one mandating automatic registration of anyone convicted of sexual offense, as being unconstitutional, as being contrary to Section 7 of the Charter of Rights and Freedoms, which protects life, liberty, and the security of the person. Now, the court in that case gave Parliament 12 months, 18 months, I forget exactly what it was, but to correct the impugned legislation, that is exactly what we did in the last Parliament. We, all the parties, worked together cooperatively to make that happen. Just to be clear, Antic was not that kind of a case. The Supreme Court just wanted to clarify things. And it was the Liberal government under Justin Trudeau and David Lametti at the time that introduced Bill C-75, introduced Section 493 to the Criminal Code. This is of their own volition. This is the Liberals appealing to their base, trying to distinguish themselves from law and order Conservatives. And now they're seeing the effect of that legislation. Public outcry. The public are calling it the catch and release provisions, and they're blaming the Liberals for that. Widespread call for bail reform from premiers, from police services across the country, from police unions, and public safety advocacy groups. So what do? Well, they introduced Bill C-14, which is before us today. What are they doing? They're bringing in workarounds around their defective legislation. We're saying, why not just get rid of Section 493 altogether? It was not mandated, it is not necessary, it is not helpful, it has been harmful to the administration of justice in this country. Time to get rid of it. Our judges on bail hearings know what the common law says about the right to bail. They know what the Charter says about reasonable bail. They know what the Supreme Court and other courts have said to guide this age-old principle. So Bill 48, Madam Speaker, from the Fourth Parliament took a small step in the right direction, a timid step. It didn't go nearly far enough, and that's why we're here today. I'm more hopeful today with the current Attorney General and Minister of Justice signaling that perhaps Bill C-75 went too far, and perhaps Bill C-5, another enactment that I didn't talk about too much in my speech so far, but which relaxed some sentencing rules, perhaps they've gone too far. Perhaps they've had a negative impact on the public's confidence in the administration of justice. It's time to fix it. But like C-48, C-14 does not go far enough. At committee, we, Conservatives, will introduce amendments to get Canada back on track, putting public safety first, putting public confidence in the administration of justice first, because that is what Canadians deserve. That is what Canadians right across the country have been demanding for a long time. It's time to get it fixed, and we will do our best to make sure that Bill C-14 comes out of Parliament as strong as possible to protect Canadians. Thank you.
Questions and comments? Questions? The Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Madam Speaker. You know, I think it's important to recognize that over the last number of months, we've had many Conservatives stand in their place and demand for the bail reform legislation. The good news, Madam Speaker, is that we actually now are debating Bill C-14. The member knows full well how important this issue was to Canadians in the last election. We have a Prime Minister that has materialized on substantial bail reform legislation. Take a look at the next week's agenda where we get the national budget coming before us. And I'm wondering if the member would not agree setting a goal that we can actually have the bail reform legislation actually pass through the system before the end of the year would be a wonderful thing to see based on the demand for it from the people that we represent and the consensus that has been built by the many different stakeholders. Would he not agree that the House should give its best efforts at passing this legislation before the end of the year?
Great question.
Honourable Member for Langley Township, Fraser Heights.
Good, thank you. I agree that the House should give its best efforts, but that requires that the Liberals give their best efforts as well to this, to passing this legislation. We're going to come to committee. We're going to have requests for reasonable amendments to this legislation to make it better. I'm very happy to see that we're having this high-level conversation in Parliament, and there seems to be substantial agreement that there needs to be bail reform. We're happy that the Liberals are finally coming to the table, and we're hoping continued cooperation at committee. Thank you.
Questions et commentaires, l'honorable député.
The Honourable Member for Lac-Saint-Jean. Thank you very much, Madam Speaker. Well, we have some concerns in the bloc with this bill, but we want to see it go to committee. We want to move amendments, and I'm sure the Conservatives will also want to come forward with amendments. There's just an additional concern which has come up because committee work on C3, for example, where there were amendments which were approved by the committee, when that came back to the House, we saw that the Liberals wanted to undo all the amendments that were made at committee through the work of the House. So does my colleague share my concerns that if we do the work in committee, if we do serious work at committee and we do good work on Bill C-14 to amend it, is he worried that, you know, when it comes back to the House, that the Liberals will undo all the work that's done at committee?
Member for Langley Township, Fraser Heights.
Well, thank you for that question. I would like to thank the member for that question. And yes, I do share that concern with the members from the Bloc Québécois that the Liberals are going to try to prevent any reasonable amendments to this legislation. However, I'm an optimistic person. I'm going back to the case of the sex offender registry case that was found to be unconstitutional. All the parties worked together. We really did to pass that legislation through. If the Liberals are taking this bail reform and sentencing reform initiative as seriously as they say that they are, then I'm pretty confident that they will, at committee, be cooperative and work with us on reasonable amendments. Thank you very much.
Questions and comments. The Honourable Member for Brantford South, Six Nations.
Thank you, Madam Speaker. I thank my colleague for his excellent speech. I'm going to ask him to reflect on the issue of the principle of restraint. Obviously, it has not been abandoned in C-14. There's been some attachments and some limitations to its application, but I'd like to hear from him as to why the provisions of the principle of restraint in jail, not bail, it would be a better approach for the protection of Canadians.
The Honourable Member for Langley Township, Fraser Heights.
Well, thank you. I'd like to thank my colleague for that question. Indeed, this bill, C-14, retains the principle of restraint, which has been at the center of the problems in the administration of criminal justice in the last decade, and at the heart of the public's loss of confidence in the administration of public justice. And I think that that is a very, very important principle. And I'm sure that our amendments at committee are going to focus on secondary and tertiary grounds, public safety, and public trust, in the, public confidence in the administration of justice. Thank you.